Give me 1 second. Let me look at something. Alrighty, my apologies. Okay, we are back on the record in cause number 2019 0D06884, State of Texas versus Gloria Ariel Nelson. And I just wanted to make sure, Ms. Nelson, that you had an opportunity to speak with your attorney with regard to any outstanding questions you may have had. I'm going to ask you again with respect to State's Exhibit number 1, the plea papers. Did you understand everything contained within that document? Oh, you're muted. Sorry. I just noticed that. Annex, if we could unmute. Thank you.
Yes, ma'am.
Okay, perfect. I didn't miss anything, did I? Because you were muted. You weren't over there saying a whole bunch of stuff, were you, Miss Nelson?
No, I was singing a song.
All righty. So with the plea papers squared away, Miss Martin, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, we have.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor, she does.
Miss Nelson, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Miss Martin, do you have any reason to believe that your client is not presently competent to enter a plea?
Absolutely none, Your Honor.
Miss Nelson, have you ever been found incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
I've been examined, yes, but actually I'm fine.
Okay. Are there any conditions, either diagnosed or not diagnosed, that are stopping you from understanding what we're doing today?
No, ma'am.
Okay. So based on your testimony, well, let me ask you this. Have you been able to effectively communicate with your attorney regarding your cases?
Yes, ma'am.
Okay. So based on your testimony, your attorney's representation, and my observations of you, I'm going to find that you are competent to enter your plea today. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
In Winslow, Arizona.
Okay. So the charge against you in count 1 in this case, both I believe were originally indicted as higher level offenses, but my understanding is as to count 1, you're pleading to the lesser included offense of possession of a controlled substance in penalty group 1 and an amount less than 1 gram. To that charge, what is your plea, guilty or not guilty?
Guilty.
And as to count 2, again, lesser included attempted hindering or apprehension of hindering the apprehension or prosecution of a known felon. To that charge, ma'am, what is your plea, guilty or not guilty?
Guilty.
Are you making your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Herrera, would you summarize the evidence, please?
Yes, thank you, Your Honor. Had the state gone to trial in cause number 2019 0D06884, the state would have proven beyond a reasonable doubt that the defendant, Gloria Nelson, on or about the 14th day of August 2019 in the county of El Paso and state of Texas, did then and there intentionally or knowingly possess a controlled substance, namely cocaine, in an amount of 4 grams or more, but less than 200 grams as to count 1. As to count 2, the state would have proven beyond a reasonable doubt that the defendant, Gloria Nelson, on or about the 14th day of August 2019 in the county of El Paso and state of Texas, did then and there with the intent to hinder the arrest of Michael Avila under the authority of a warrant or capias, harbor or conceal Michael Avila. At this time, Your Honor, the state would enter State's Exhibits 1, 2, and 3. State's Exhibit 1 being the plea papers, State's Exhibit 2 being the Article 3914 disclosure form, and State's Exhibit 3 being the indictment and case summaries.
Any objection?
No objection, Your Honor.
Without objection, State's Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, as to counts 1 and 2 is to a lesser included state jail felony via 1244A, 150 days confinement in the El Paso County detention facility with credit for time served.
Ms. Martin, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
And Ms. Nelson, is that your understanding as well?
Yes, ma'am.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Ms. Nelson, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Okay, signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept pleas at this time, find the evidence substantiates your guilt. In count 1, I will find you guilty of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. In count 2, I will find you guilty of the offense of attempted hinder, apprehension, or prosecution of a known felon. In each of these cases, I will follow the plea agreement and also in accordance with 1244A of the Texas Penal Code, sentence you to 150 days confinement in the El Paso County Detention Facility. These will run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Ms. Herrera or Ms. Martin?
Nothing further for the state, Your Honor.
Your Honor, just to make sure that a release order is signed for her.
Okay, I will check with the clerk as soon as I receive it. I will sign off on it.
Thank you, Your Honor. Maybe we be excused?
Yes, ma'am. Good luck to you, Ms. Nelson.
Thank you.
Did we ever get Mr. Aboud back?
Judge, I emailed him anew, and then both Chewy and I called him, but his answering service picks up.